Hey, what's up, everybody? It's Stephen Williams, founder and president of the creditrepairshop.com. In this video, I'm going to do a brief update on Santander. Everybody out there probably knows that Santander entered into a multi-state settlement agreement. Let me get into that real quick. Okay, just a quick review. Santander Consumer, which is a subprime auto lender, entered into um, a settlement with 34 states, but it's also a new one going on with the remaining states. And basically, what it came down to was the settlement was they agreed to pay $65 million for restitution for subprime consumers who defaulted between January 1st to December 19th, but it was also extended to May 2020. And these were people that were wronged with the way that the loans were either put together. They had what was called an internal scoring system. There was something that they called power booking, where the dealers overestimated the value of the vehicle just so they can get the loan put through. They lied about people's expenses. Just even though they couldn't afford the car, they would put them into the car. Let's go here. And also, there's been no updates on this website. Look at this since May 19th, 2020. It said for the people who qualified, they could get, let's see here, I think it was 200 and something dollars that they could get if their car was taken, but they're supposed to also get all of the negative information removed off their credit reports and any debt deficiencies that they owed from the repossession. They're supposed to get that back too. Here it is, $224.80, which is nothing. Um, the other parts was the way the deficiencies, and some people could actually get their loan forgiven in the car title, which they are fighting very hard on that. Just to keep you updated on it, is that Santander is in charge of everything on how long it's going to take, which they have to have it resolved by December 31st. But it is stipulated in the settlement that people have to continue paying for their vehicle, even if they're going to have loan forgiveness and they're not going to give any of that money back. So even if your car is going to be paid off, you're going to get your title, you still have to keep paying until Santander gets to your file and deems it that they're going to give you the car. So you're going to have to pay money. And what's been happening to a lot of people is they've been paying money and they're getting upset because they know that they potentially should be in the settlement. They've submitted documentation to be in the settlement. Some people have submitted documentation through the law firm that I've contracted with, but they're being very slow. But we did get we have gotten responses. There's been people that have gotten their deficiencies waivered, where they're not going to come after them for the money. There's debt collectors that have sent the deficiency waivers back to Santander, so that's been happening. But this part here is what's really the shaky part on how they're able to get away with making people have to pay or they're going to take the cars back. Because this is my own opinion, they're building up for their money that they have to use for the settlement, the millions that they have to use for the settlement. They're actually getting that paid by people that are paying on the car, even though the debt's going to be forgiven on the vehicle, and they're going to be able to get the car title. So that brings me to what one of our customers sent me, and I thank you for always keeping me updated on stuff that I don't come across. And this was a settlement. Well, not a settlement. This is where a resident of the state of Wisconsin, which I'm in, sued Santander. And this is what the suit was based on. And I'll put the link so you can take a look at this here. But when I looked at this settlement or this uh, court uh, missing my words here, where this gentleman won in court, had a decision based go in his favor because what has actually been revealed, which is something that I had always thought that was strange with Santander, was that Santander was actually in the business of collecting its own debt. Usually, when a company or someone, a bank, you get a bank loan, you get a loan from a finance company for a car, is that they never would be the ones that would come after you for it. They would sell that debt, and then there was a debt collector coming after you for it. And there's a reason behind that. Is because you have to be deemed a debt collection company, and you could be breaking all types of laws by going after people for the debt that you had for your originally with your company. Now, if you are your own company and you're going after a person for debt, it's in a whole different classifications. But what Santander did was to a way to scare people, a way to get people fearful, was to assume the position of a debt collector. And I want to show you some points here where they showed right here. According to Santander's website, they're in the full service technology driven consumer finance, focus on vehicle finance, unsecured consumer lending. But what happened was they started acting as a debt collector for their debts. And when they did that, they were submitting documentation to people as if they were a debt collection company. They're attempting to collect the debt. When you use certain words like that, and the reason why they used those words when they were trying to contact people is that they wanted to get them fearful that we are a debt collection agency coming after Santander's money, or we are Santander coming after our money, which they have a right to come after their money, but not after you like a debt collector. When they started coming after people as a debt collector, especially here in my state, especially here in my state, when you are deeming yourself, sending out letters and calling people and trying to hunt them down to pay a debt, and you put yourself as a debt collection company, a whole bunch of other rules come into place. And when I did my research in other states, this is actually what Santander has ran into with other states. So this was actually another class action lawsuit that was, that was put into place from other people that had made the same complaints about Santander. Now, this didn't involve as many people as it did with the larger lawsuit with the 34 states, but this is similar. That Santander broke rules when they were number one getting a judgment for a debt that they have, and then turning around and flipping around and pretending like they either sold a debt to someone, but it was really them coming after people for the money on their own debt. But they tried to use words and scare people. Now, they showed some stuff here where they had actually broken the rules right here, where they were saying words like, this is a 30% settlement offer. And what they did is they got people thinking that this was something that they had to do. And it's against the Fair Debt Collection Practices Act to use terms like this. And you see this thrown out there by a whole bunch of different companies where they're like, this is a settlement offer and you got to take this right now. Now, there's a term that they use for that is false. This is false and misleading, number one, that you have to take that amount. But there's a term. Let's show you here language, safe harbor, where you cannot send people debt collection letters making them think that this is a one in a lifetime type deal that you're offering them. That is actually breaking the law when you do that. You cannot make those types of statements. And they say that consumers, an unsophisticated consumer, has a false belief that he or she must hurry and take advantage of the limited time opportunity. So you've probably gotten this same type of debt collection offer from other debt collectors. And one strategy, which now that I'm even becoming more aware of this, uh, that they cannot make those statements, is that uh, maybe what all of everyone should do, including my company, when they make these types of settlement offers and they make those statements, is that we send them letters back stating that you've just broken what's called a uh, safe harbor. Uh, you you've used a statement which is considered safe harbor language regarding a statement offered in a collection letter, which they cannot use that. And I bet you when those types of letters are sent back to them, that they would probably cease all collection activities, and they will send a letter stating that they're going to cease all collection activities because they know that they've actually broken the law. And a lot of people don't know that they are not allowed to do that. So I'm going to post this on here, but basically what this came down to was that they were actually had gotten a settlement, had gotten a default, or not a default judgment, gotten a judgment for from this individual a year before, and then they used the same information to try to go back into court to get a judgment for the debt collection so they can try to collect on it that way to probably move it forward to be able to do a garnishment. And they use the same documents, which is not, you can't do it that way. They broke all types of laws. And when I've researched it, they've actually done this in several different cases, and several different attorneys have brought lawsuits and have won when they've done this with other consumers, where they had a debt and then they went after them as though they were a debt collection company, but they were not notifying the individual that they were coming after them as a debt collection company, but they were using all of the terminology, all of the letters, all of the collection calls and everything as if they were a debt collection company. So this is really getting interesting. There's a lot of problems that Santander has put themselves into, but they're still doing business as usual. You know, this is a multi-billion-dollar company, and I guess that they're just feeling that this is just part of their business model, which is if people take us to court, we go to court, we deal with it. As long as no one is going to jail over it, they're going to just keep doing it. They don't care. So this is Stephen Williams, founder and president of the creditrepairshop.com. If you want to have the attorney law firm that I'm working with make a demand letter for Santander, the links are below this video. And, you know, it's just going to be a fight. This is not going to be something that's going to be over with in 1 month, 2 months. It could take as long as a year. You never know. But no action is going to happen unless you take action. And I revealed this individual's name because this is public record. That's the reason why I placed this on here. Usually I would cover them up, but this is public record. So this is Stephen Williams. Please like this video. Please share, comment. Let's keep finding more information about Santander so we can help other people fight for their rights. And we can see here that they were deemed as a collection agency in the state of Wisconsin, which made their collection activities illegal to come after this individual. All right, thanks a lot, and until next time.